At this point, I'm going to hand over to Darren Fittler, our next session chair. Thank you, Darren.
Hello, it's Darren here, just doing the typical check 1, 2. Can you hear me?
Sure can.
Fantastic. I'm just now also going to put my phone, I've had to do this by phone, everyone, so bear with me. I'm going to put in a little tripod stand here and see from there. All right. Okay. So hello, everyone. My name's Darren Fittler. I am a partner at Gilbert and Tobin. I have a practice serving charities and not-for-profits, and it's fabulous to be amongst all of the presenters and all the viewers' audience, being people who are as interested and keen on serving charities and understanding and getting better at charity law every single day. And where a lot of interesting changes occur is in the tax space. When we really break it down, after all, why does a charity really want to be a charity? Mostly because of the fabulous charity tax concessions that charities are eligible for, both at the state level and at the federal level, and even at the local government level in certain circumstances. So it is my pleasure to be chairing this panel session today on new matters arising in tax. And today is really going to be more of a deep dive into one particular matter. And I won't go into any detail about it because we have the experts here on the panel. I'd like to introduce to you Jeff Mann and Alice Kim from Ashurst in Melbourne. And they are both experts in indirect tax, serving charities, helping with deductible gift recipient status, looking at various state concessions around payroll tax, land tax, stamp duty. Jeff is a partner, has been serving in this space now for 30 years or more. And Alice has also been dedicating herself in this space for some years. Jennifer, have you managed to join us? I can't hear Jennifer. So
Jennifer's online, Darren, but she may not be at her computer right now.
Right. So Jennifer, her other duties and obligations pending will also contribute on this panel discussion. But don't tell Jennifer I said that. I think that we have Alice and Jeff here who can do perfectly fine without her. So without any more further ado, I would like to hand over to Alice and Jeff to take us down this journey.
Thank you, Darren. I might just share my screen if possible.
Yes.
So I've got a couple of slides, so that didn't work. Okay, just double checking that everyone can see the slides. It should be up on the screen. Yep, okay. So I'll be taking you through the case of the University of Melbourne and the Commissioner of State Revenue to 2021 VSC 156. And this case looked at the meaning of used and exclusively in this in section 74(1) of the Victorian Land Tax Act 2005 in the context of the charitable institution exemption. So the University of Melbourne held land in Carlton, which was next to the Melbourne Law School and the Education Faculty. And it had wanted to build a student accommodation facility that would include student support services such as 24/7 on-site assistance, an induction program, and pastoral care. In 2014, the university and a commercial student accommodation provider, Campus Living Villages, or CLV, entered into an overarching project deed in respect of the design, construction, and operation of this student accommodation facility. CLV will build and operate the student village under a lease of $1. CLV would then sublease the rooms of the village to the university students. Rent and fees charged to students to residents of the student village were inclusive of these student support services, which had to be approved by the university, who set an affordability criterion below market rental. Accommodation at the student village was required to be allocated to the university students and staff before being offered to students at other universities. The university maintained overall power to monitor, audit, and test CLB's compliance with the project deed and whether it was consistent with the university's objectives and policies. Now, as part of the student village, a sublease was granted by CLB to a cafe as part of a number of facilities made available to students on site to enhance student living experience. In 2019, the university was issued a land tax assessment that assessed the land on which the student village was located. The university objected to the land tax assessment on the basis that the land should be exempt from land tax because of the exemption in section 74(1)(a) of the Land Tax Act. That section provides that land is exempt if the commissioner determines that it is used by a charitable institution exclusively for charitable purposes. The university's argument was that the exemption should apply to the land as the university was a charitable institution which used the land exclusively for its charitable purpose, being the provision of student accommodation to its students for the advancement of education, and that the involvement of CLB was merely a conduit in which the student accommodation was delivered to its students. The commissioner disallowed the objection on the basis that the land was not relevantly used by the university, but by CLB, who was operating the student village on the land for a for-profit activity. The university then subsequently appealed to the Supreme Court. Now, at the appeal, the university contended that the existence of a commercial lease to a non-charitable institution would not, and in and of itself, deny the operation of the exemption. Relying on the High Court case of Ryde Municipal Council and Macquarie University, which held that Macquarie University was exempt from rates on the land that was leased out to various shops and banks on campus, the act of leasing by the charitable institution still constitutes use. Further, upon the legislative history and the extrinsic materials relevant to section 74(1)(a) showed that the exemption was for land used by a charitable institution, regardless of ownership of the land and regardless of whether or not it was leased or occupied for any business purposes by a third party. Just change the slide. In 2001, amendments were put through which had carved out the application of the exclusion of the exemption to any leased parts of the land or occupation for business purposes to a person or corporation that was not a charitable institution. This was carried through to the current version of Section 74 of the Land Tax Act. The university submitted extensive evidence, mainly two affidavits, one from the current Chief Operating Officer of the university and a former General Manager of the CLB's student facility, which provided evidence as to the student accommodation being an ingrained and integral part of the university since its inception in 1853, the importance of the university maintaining control over the student accommodation project with CLB, and CLB's compliance with the university's requirements under the project deed in its operation of the student facility year to year. Whereas the commission accepted that the university was a charitable institution, although CLB was not, and that the provision of the student accommodation by the university was a charitable purpose, but not every means of which that purpose is pursued is charitable. The commissioner contended that the extrinsic materials and the legislative history indicated that Section 74 was limited to active physical or direct use of the land by the charitable institution, and the deployment of the land for advantage, such as by way of the lease, did not constitute a use for the purposes of Section 74. Alternatively, if a lease was a use of the land was also being used by CLB to make a profit, and as such, was not being used exclusively for charitable purposes. So in his decision, His Honour Justice Osborne found in favour of the university and allowed the university's appeal. His Honour held that the text and the surrounding exemption provisions indicated that the term used, as it appeared in the Section 74(1)(a) provision, was not synonymous with occupy, The text indicated that the meaning of the word use was wider than active physical occupation. This wider meaning of use was consistent with the legislative history of the exemption and the approach taken to the analogous provisions in the Local Government Act 1919 by the majority of the court in Wright Municipal Council and Macquarie University. The sense in which the word use was construed by the majority in Wright was a matter that the legislature would have been aware when it passed the subsequent amendments to the Section 74 Land Tax Act provision. As for the meaning of exclusively, the manner in which Section 74(1)A was drafted, that is immediately preceding the phrase for charitable purposes, rather than before used, pointed to an interpretation that was referable not to the use of the land by the charitable institution, but to the purposes of the institution itself. While the university's provision of student accommodation was indirect, it retained an ongoing involvement in the activities conducted on the land in a manner that went beyond the arrangements that would ordinarily be part of a standard commercial lease. The sublease of the part of land for the cafe constituted an incidental or ancillary use to the main charitable purpose of providing student accommodation, and that land was also exempt. It was clear on the evidence that the cafe was one of the facilities made available to students on site to enhance the student living experience. In particular, the evidence showed that the cafe was chosen in order to provide students with wholesome foods at reasonable prices, and the cafe being a common area of the residents. Now, Geoff will contrast this case with a recent Illawarra decision in the ACT, which was handed down on the 25th of June, 2021, very shortly after the University of Melbourne case.
Thanks, Alice. And I just want to get it on the record that we couldn't have done the work on the University of Melbourne case without Jennifer Batrouney, as well as Chris Sievers, who was our junior on that. So just to contrast with Darren's tempting of fate. So in relation to the University of Melbourne, I mean, it was really interesting that a lot of the time and effort that went into preparation for that case was spent on those two affidavits. It doesn't sound very much, but they were incredibly voluminous, and there was a lot of reference to that evidence by His Honour in reaching the decision, and I think it really helped a lot. And one of the points of contrast with this recent case dealing with retirement was the lack of evidence. So what happened in Illawarra Retirement Trust was a body that was involved in the provision of aged care and retirement villages, which was charitable, had purchased a property which it had a multi-use development proposal for, which included the retirement village, but some shops, cafe, beauty services, but also a childcare facility that was located on the land. And economically that made sense because they could then get some money back for the childcare facility, and that would assist in their overall objectives of developing the property for the retirement village. There was said to be, I suppose, an intent that the childcare facility was there for the benefit of, I think it was referred to as multi-generational living, so that the retirement village would have a community around it. You would have, people coming and going, there would be children around, there would be the parents coming to collect their children, and that was said to be all beneficial for the residents of the retirement village. So while some evidence was led from one of the officers of the retirement village operator that was the intent, ultimately there was really no evidence of the connection between childcare and the retirement village such that there was any obvious benefit that was being provided. So unfortunately, although there was this stated objective, there was a lack of evidence. And so in the end, the exemption that was being applied for here under the Rates Act in the ACT did not apply to the part of the land that was being used for the childcare facility. Still got the exemption for the rest, and the council had accepted that the retirement village and the incidental retail areas, the shops, the cafes, the beauty services, which the retirement village residents could access, that was all exempt from rates. But the childcare facility was not. The other point that this sort of gives rise to is, well, where's the line here? Was it purely a lack of evidence? I mean, that's always a bit of a problem if you don't have evidence to support your case. But was that the real issue here, or was childcare seen to be so different and so outside the realms of retirement village living and the provision of that benefit that it was never going to qualify anyway? And I suppose there's a bit of a question mark over that, because I said it got knocked out on the lack of evidence point. Whereas a cafe, you know, we were successful in getting the cafe included as being incidental. You know, that was seen to be something that was for the obvious benefit of the students who were attending the university. So there is a fine line there, perhaps, and we're not quite sure where that is. And again, I made the point that economically it made sense for part of this property to be developed into a childcare facility, because money could be, you know, made from that operation. But that then, I suppose, brings us on to the word investments case. And this is where I'm more than happy for Darren to chime in as well. But Alice, if you just want to flick to the next slide. The issue here is, in the University of Melbourne case, we didn't need to raise the decision in word investments, and it wasn't raised in the Illawarra case. But this is the question mark that I still have in my own mind as to where the dividing line is in relation to exemptions such as we had in Section 74 of the Land Tax Act, where it talks about exclusively for charitable purposes. Because in word investments, you'll, I'm sure, all be well and truly aware, it was held that the for-profit commercial activities that were being conducted by word were still held to be charitable, because those activities were being undertaken for the purpose of raising money, which was then applied back to the charitable purpose of the organisation. The fact that those activities of themselves weren't inherently of a charitable nature didn't matter. They were still held to be incidental activities to the overall charitable purpose of the organisation. So if word means that, then isn't pretty much everything a charity does, where the profit that might be made from that activity, or the surplus funds that might be made from that activity, are ploughed back into the charitable organisation's charitable purposes? If they're also charitable under word, then why is there any need to draw a distinction at all? It's very difficult in my own mind for me to figure out where that line is. The leasing out of the space to a for-profit to conduct student accommodation for the benefit of the university's purposes overall, the cafe, the childcare facility, where is the line? And that's the bit that I'm still struggling with, to be honest. And unfortunately, neither the University of Melbourne or the Illawarra cases really take that any further, because it didn't need to be raised in one, because we got there anyway, and it wasn't raised in Illawarra. So I suppose we're still waiting. And, you know, word's been around for a while now. These exemptions have been in this form for a while. So where does that take us? Darren, I don't know whether you wanted to say anything about that.
Nothing directly about that, but what I found was quite interesting in recent times is I had cause to have a look at the South Australian Duties Act from 1923. And it's been updated over the years. And when looking at whether or not there is an exemption available for duty for residential or primary production land, there is a provision that says the exemption won't be available if the land is being used for commercial use, even if that commercial use generates money that is channeled back to the charitable purposes of the organisation. Which feels like it's trying to almost draft around word and effectively try to install a concept, if you like, of the unrelated business income tax, the UBIT, which we all saw die a death some many years ago now. Most of us, I think probably all of us, hope stays shelved and dead. But it still then raises the question that what do we mean by commercial, even in that context? If you are running retirement village, residential, aged care facilities for a fee, and that fee is used to further your purpose, and providing those services is in the furtherance of your purpose, you would hope that the Revenue South Australia, if pushed on it, would agree that the mere charging of money doesn't turn it into something commercial, and that the exemption is still available should you apply for it. Contrast that with potentially an organisation buying a car park or a standalone cafe for the sheer purpose of generating money, then I think that's a bit clearer, at least if, you know, on a South Australian revenue kind of analysis and its drafting. But there are slight tweaks and nuances and differences across land tax, duties tax, and payroll tax, even within jurisdictions. And then there are the same issues of difference floating from state to state. And so I'm just wondering whether Alice or Geoff, you have any kind of observations or thoughts or words of wisdom around what the Melbourne University case in particular, but sort of some of this more recent thinking coming from these cases might mean in the context of some other jurisdictions.
Yeah, we've got there for people's benefit the provisions from the land tax, the duty and the payroll tax legislation in each jurisdiction. And there is a divergence of the wording, as Darren said. That South Australian one is interesting because, as you say, Darren, it seems a very targeted response to the word situation, but still with a question mark over exactly how it applies. At least, I suppose, when you've got some clear words like that, you would expect you've got to be able to find a line somewhere. Whereas I'm still a little bit in doubt if you look at that Section 74 in the Land Tax Act in Victoria, and then you look at the payroll tax exemption, for example, which in many jurisdictions is worded around the employee, the relevant employee being engaged exclusively for charitable purposes or exclusively in a kind of work ordinarily performed in connection with those charitable purposes. It starts to get a bit grey. So unfortunately, I'm not sure that I have any great words of wisdom other than to say that I do struggle a little bit with figuring out where those lines are, which I suppose is why we ended up in court on the University of Melbourne case, because we thought it was somewhere and the State Revenue Office thought it was somewhere else. And inevitably we let the judge decide, but it does still lack clarity. And you know, if Jennifer were here, I'm sure she'd be able to add something to that because she's been through the ringer on. Sorry, Jennifer. Hi.
Hi.
Good. Perfect timing.
Sorry. Yeah. Look, I'm sorry I wasn't here a bit earlier, but I think in all these cases it depends on the perspective that you look through. So, for example, in the Melbourne University case, as I think Anne Robinson has pointed out, the land tax cases tend to be focused on the use of the land, but there were many users of the land. Like the university successfully argued that it was using it to provide student accommodation. The commercial operator was using it for the same purposes. And then, of course, the students themselves were using the land for their purposes. And an important point coming out of the University of Melbourne case was that particular provision in the land tax looked at it from the perspective of the university. So from the perspective of the university, it was being used for the university's charitable purposes. From the perspective of the provider, the commercial provider, it was being used for commercial purposes of the provider. And the Commissioner for State Revenue unsuccessfully sought to elide the two, to say that the university's purpose was somehow subservient to the commercial developer's purpose. So as Geoff's pointed out, it does leave open for another day, perhaps, the question about what would be the situation if the land was not being used for charitable purposes in the sense of student accommodation, if it was simply being used as an investment property. That sort of word investments inquiry, I think, is still open. I don't think that the University of Melbourne case has shut off that argument, and certainly that argument was live in in the case that we relied on, the Ryde Investments, the Macquarie University case.
Thank you, Jennifer, and welcome to the panel. Great to hear your voice and to have you with us. If we were to apply some of this logic to other analogous situations, even say within Victoria, so at least we're playing with the same law and the same jurisdiction, would either of the panelists like to hazard some thinking around what this might mean for using commercial developers of undeveloped land for affordable housing?
Yeah, I mean, we've been doing a bit of work in that space. Obviously, build to rent and affordable and social housing is a bit of a flavour of the month. And so we've been doing a little bit of work in that space. But suffice to say, a bit like the provision of student accommodation for universities, there are several models that are able to be utilised for delivery of affordable and social housing. So many of those do involve a charitable body, a community housing provider in that process. And so sometimes it's sort of the character is obtained from the involvement of that body, and it being charitable, then you get the benefit of some of those concessions. For example, in the GST space, and in Victoria, again, you'd probably be looking at exactly what are those arrangements, what's the ownership, what's the tenure around the land to work out whether that is going to get that charitable exemption. But you'd probably think on the basis of our University of Melbourne case, that if the charitable housing provider is owner of the land and it's involved in providing that land to people in an affordable or housing situation, that they should qualify for the exemption. That's aligned with the overall charitable purpose, the provision of the housing. So I would have thought that should qualify. We have done some work with other housing providers and been able to obtain registration with the ACNC and the various tax endorsements that go along with that on that basis. So I wouldn't see a problem with that in the sort of context of the land tax exemption in Victoria.
I think I'd be grateful then to hear anybody else's questions or any thoughts from the floor to share. We've seen quite a few notes coming through on the chat, so thank you for that. But if there's anybody that would like to ask a specific question of any of our panelists, or just generally about the case or its consequences, I guess I open the floor.
Darren, it's Ian Murray here.
Hello, Ian.
One question I was curious about was how the Melbourne University case ever came to court. I can see how the Illawarra case might have elicited some different views, but I really struggle to see how the provision of student accommodation would not be seen to be aligned with the university's educational mission, even if provided through a third party. And I was just wondering, is there some backstory as to why this came to court in the first place?
Can I introduce you to the Victorian state revenue authorities? That they initially denied that the provision of student accommodation was charitable. So that issue was live for a long time in the case, and occupied a lot of our time in preparing the case to try and establish, if it mattered, that it wasn't just a case of us asking the Hyatt or the Hilton to build some accommodation and we'd throw some students in there. We established that the university maintained very tight control on the build and the operation of the accommodation. So it was very important to the university that the accommodation was not just four walls and a bed, that it was part of the student experience. The students were looked after, the students were made to feel part of the university agora, and that the accommodation was appropriate for those needs, and they had ongoing control and in fact ability to nominate students to actually fill quotas, as it were. Would it have made a difference if it was if the university had just given the land to, say, the Hilton or the Hyatt or whatever to run commercial accommodation? Don't know. Again, that's a question that perhaps remains open, but because the Commissioner of State Revenue at first instance said it wasn't part of the university's charitable purpose, they tried, you know, in the same way that in Word Investments, they tried to say that the operation of a funeral business, a commercial funeral business, was a separate and independent commercial object of Word, as distinct from furthering its charitable purposes. The High Court wouldn't have any of that. And in my experience, none of the revenue authorities around Australia and perhaps New Zealand have come to terms with that concept that, you know, raising revenue to be applied for charitable purpose is in itself a charitable purpose, no matter what that activity is. It's that age-old hoary chestnut, the difference between activities and purposes. If the reason that you're running a commercial enterprise, so-called commercial enterprise, is to raise money for your charitable purposes, then that the High Court says that is a charitable purpose in itself. However, I think, as Anne Robinson points out, there's a slightly different inquiry in relation to land, in that it focuses on use of land, not necessarily the purposes. And Ian, we ended up getting indemnity costs against the Commissioner of State Revenue. So that does make one feel a little bit better. We kept saying exactly what you were saying. Why are you running this case? I think the point is that universities around Australia are looking at a number of different ways to try to provide student accommodation, and the State Revenue thought that this one just tipped over the line as being too commercial. Jeff, you might have a view.
Yeah, I think you know, that's. I'm glad you said it, not me, Jennifer. But the issue I think the State Revenue Office had, and that they did point out early on, was that this particular section had not been the subject of any judicial consideration, and they realised that RIDE was a problem for them, but tried to distinguish it. And I think they were very keen to test the limits. So that problem that I have with figuring out where the line is, I think the State Revenue Office had similarly had the same problem, and so they were pretty adamant that they wanted to test it. And you know, notwithstanding that we didn't necessarily want to end up in court, I think they probably did. They wanted an answer. Interesting, having gone that far, there was no appeal. So, you know, I think having had a decision, the State Revenue Office presumably now can go off and think about that. We were a little worried that it might prompt some government reaction to narrow the exemption or clarify the exemption. That hasn't happened, I'm glad to say. So hopefully it won't. But yeah, I think they were just very keen to test where that line was. But it probably wasn't the best case to do it.
And just, Ian, in relation to student accommodation, there is ACT decision in the John 24th or John 26th case that implied or said that student accommodation is not charitable. However, that case, it's fair to say, has been distinguished. So there was, you know, I think Jeff's right. They don't like RIDE, and they were hoping that a new Supreme Court judge might be silly enough to apply a minority High Court judgment, which didn't happen.
Universities are increasingly involved in all number of ventures and in all number of things. And I'm interested to observe that in a slightly different way, that when we look at deductible gift recipient endorsement, universities have deductible gift recipient endorsement, and sitting alongside that in the table in the Income Tax Assessment Act, there is no special condition. It is basically, you can give a tax deductible gift to a university for the university to just get on with whatever a university does, it occurs to me. Universities are doing everything from inventing and investing in new solar cells and robotics and AI to various things around medical interventions and health research. I know that we've sort of said that we don't quite know where that line is, but how far from student accommodation do you think a university could stray and still convince a court that the land was being used for a charitable purpose?
Interestingly, Darren, the history of this section, we traced it back to 1910 when the original land tax exemption was a blanket exemption for the University of Melbourne. So, the land tax exemption, in a sense, was the same as the income tax or the DGR situation today. Again, you're right. Universities are changing the way they operate. They've been forced to as a result of COVID and the lack of international students, for example. They, in some cases, sit on very, very large bits of land. And you do wonder at what point will we fall off the edge of this exemption. So, for example, if a university decides that it's got some vacant land, which would be better utilised by, say, a research partner, some industry body or a corporate getting involved and taking some occupancy nearby and conducting activities that might be in conjunction with the university but nonetheless separate, and the university simply leases that land to the industrial organisation, would that still qualify for the exemption? And that's a bit of a question mark.
Or you go to an even more extreme example. It's got some land in it. Let's, at the new Crown Casino, build a casino on it and for a peppercorn rent. I mean, I think the answer is that if it's ultra vires, the university's statute, then it will be outside the university's purposes. And that's what State Revenue tried to argue in the Ride case, that providing a student village, a commercial bank, a commercial hairdresser, etc., was outside the university's purposes in their charter or statute. So I think to the extent to which they can tag it in as research or tag it in as sort of education in some sort of way, they'll be fine. But if the minute you go to, as I say, like something that's ultra vires a university, such as running a casino, then that's the end of it.
Yeah. Matthew Harding, you made a comment just now. Did you want to elaborate with our panelists?
Oh, yeah, thanks, Darren. Well, my comment was another way you could look at this is to think about the policy objective of the land tax itself, and that might tell you something about the extent to which charitable use should be exempt. I don't know whether in your researches to prepare for the case you uncovered what the policy objective of the land tax in this statute actually is.
Yeah, Matthew, thanks. That's a really good question, and it was incredibly important, I think, in the process that we went through in analysing the strength of our case, but I think it was also important to the judge. There was reference in the slide to the State Revenue Office arguing that the history of the provision supported their case. We similarly found that the history supported our case. We had gone back, as I said, to the original exemption that was included in the 1910 Act, which was for the University of Melbourne, full stop, which had morphed over time into the exemption that you now see. But importantly, as Alice had pointed out, the removal in 2001, I think it was, Alice, of the carve out from the exemption for land that was leased. And so we were able to sort of track through the legislative history, and that supported our argument that the way that you should read the current words First of all, didn't preclude exemption for land that was leased, because if that was the case, why did they take out the carve out from this particular exemption? But also the focus, as Jennifer had said, the focus on the university, the focus on the use of the land from the university's perspective. And, although use of land, you might think it means some sort of physical occupation or application of the land. That was not what it obviously meant once you'd reviewed the history of the provision. Clearly the university is not a tangible entity that could occupy the land in that physical sense. And so to read the provision in that limiting way was ridiculous. And that all came out from that history, or the policy, if you like, of that exemption over time. So yeah, it was, I think, very important in getting to our own views about how the exemption applied, but also I think greatly assisted the court.
Yes, thanks for that question, Matthew, and those responses. And I've noticed a comment come through from you. If you're in a place where you can unmute and talk to the panelists.
Yep, I can.
Oh, great. Thank you, Mann.
Sorry, I've just been looking at other screens. But yeah, look, I think certainly the New South Wales land tax cases we're aware of that, say, for example, have involved PBI exemption. It's very clear that it's the actual use, it's the direct use, not the purpose use. So a PBI, for example, that leases some property, makes some money from it, that it obviously applies to its PBI purposes, that's not going to cut it with the land tax exemption. And there's certainly a very long history of that kind of application of the exemptions. It's really the actual use of the land. So that's what I meant by the connection to the use, and which of course is sort of in a funny backward way, like Word, because Word was focusing on what Word was going to do with the income produced, not actually the funeral business, which could have been a charitable purpose in itself had they so wanted to do that, but I won't go there. But yeah, so it's certainly, it is the use of land is the real problem. And what I think is interesting about the case you just talked about was the preparedness to say, well, you're using it through a third party, a commercial developer, but you're still actually using that as a means to that end. And that's what I think is so interesting about that particular decision. It's almost like a preparedness to look through to see whether that's actually a way of, it wasn't a commercial arrangement to any old developer. You've made that very clear, and the university kept key interest and involvement in the process. So it was I think it's a very interesting case, and I think it'd be really interesting to see if, what other perhaps jurisdictions will make of it. I think it's very interesting. Thanks.
I mean, it's interesting comments, and that it's sort of an iterative process. I suppose once one accepts that university students need to eat at the university, they need to have somewhere to have lunch. And the minute you accept that the Chancellor of the university doesn't have to cut up the sandwiches himself, then, as they said in RIDE, there's a number of ways in which facilities can be provided to students. They can be provided directly by the university employing its own staff. They can be contracted out to a subcontract, for a cafeteria. Spotless could run the cafeteria, or some other combination. And when you think about it, it makes sense. A hospital doesn't lose its exemption, doesn't lose its charitable status because it subcontracts out the cleaning or the cafeteria to some commercial entity.
Yeah, but a lease of the property is a different thing, isn't it? When you're talking about land tax and exemptions for the actual use of land, I think the key is it means to an end. You might be leasing it to a third party, or if through a more complex and sophisticated commercial arrangement than a pure lease. It's a means to an end of providing student accommodation, which, if you've looked even casually at some of the old University and Corporation Acts, which makes very interesting reading. And this is a shameless plug for the last session which our Sydney University colleague is going to talk about. But the notion, the inherent part, for example, of the Sydney University Act was the provision of colleges. It was the University and Colleges Act very early on. And the whole notion of providing, and some of it was quite quaint and quirky, because when these young students were, in the big bad city and they had to be looked after by the colleges, it makes really interesting reading. But I think the notion of university accommodation is part of the project, the university project, and I think therefore is a different thing. I don't know whether you argued that in your submissions at all.
Well, it's interesting. At the University of Melbourne, all the colleges are but for a couple, are provided by religious entities. So the Catholic Church, the Anglican Church, etc.
Correct. And if you look back at the original Incorporation Acts, which is a nice bit of quirky background, they actually weren't established for the advancement of education. They were incorporated they're established for the advancement of religion and good living, not education per se. That came a bit later. Anyway, interesting stuff.
Well, I think we're coming to the end of our time together. Thank you everyone for your attendance. Thank you for putting up with my lockdown locks. A bit of a mop here. I haven't been able to do much about that. So that's my new term, lockdown locks. You can take that if you like. But I might just give one last minute to our panelists. Any final words from Alice or Geoff?
No, I'm good. Thanks, Darren.
Oh, good.
Well, thank you. I know we're all in our separate places. You can clap if you like. I'm going to. If you join me in thanking our panelists, and I hope you have a great rest of the conference. And for those joining tomorrow, who knows, we'll cross paths again then. So thank you again, everyone. Bye now.
Darren. Thanks very much.
Thanks, Darren.
Thanks, Geoff. Thanks, Alice.
Thanks,
Thanks,
Jeff.
Darren. Thanks, panelists. We'll see you back at 3.